Good morning, this is Jen, the Liberty Lion, and I guess it's actually afternoon, but today I want to go over the Roe versus Wade issue. So recently we've seen that Roe v. Wade may be or may not be overturned by the, quote, Supreme Court of the United States, end quote, and that has brought out certain individuals who disagree with the government at the federal level, which has no say in determining abortion rights or abortion wrongs. Recently, we heard one person state that abortion is not in the Constitution, and so the Supreme Court has no right to make Supreme Court case opinions based on anything that's not in the Constitution. And this is why I brought this channel forth. It's for truth, so that people can learn what's real versus what's not real. I've heard a lot of crazy things out there in the so-called patriot movements, and people are selling these crazy ideas to people at a cost, and it's costing people a lot of money. And so I decided that I wasn't going to listen to the BS anymore. I was going to try to bring forth things that I knew for a fact to be true, and that I would base the things that I say on fact or articles written by legal scholars, legal students, by universities, law reviews, by Congressional record, federal reports, federal laws, statutes, regulations, codes. And when I was doing an interpretation, that I would state that it was something that I was interpreting or something that I had experienced but didn't have the actual proof to show. But sometimes those things can lead us to understand the proof that we're looking at. So this channel is supposed to be to help people understand what is and what is not, so that you can move away from believing the silly things that I had heard in the so-called patriot movement. And some of those things are, people were saying things like the placenta was, the birth certificate was actually for the placenta and not the baby. And things like there's a black credit card, and that you can get a black credit card from the government, and as long as you sign a non-disclosure agreement, you can buy whatever you want or pay for your utilities or so on and so forth, these silly things. The only credit card I had ever seen that a government person could get was a fuel card. And back in the 90s, I don't recall these fuel cards ever even having any name or numbers on it. It was just a magnetic strip, kind of like the ones you see when you go and you unlock the door to a hotel room or something. It's just a magnetic strip on a card, and it would say fuel card, and it was usually on the key ring, had a little hole punched in it, and it was on the key ring of the vehicle key. So these are just a couple of odd things that people were saying that I knew or felt were untrue, but yet other people were buying into these things. So that's why this channel was made, and I went on a search to find all the information I could to back up what I had learned in the military and working as a civil servant. And Eisenhower's reports were probably the most foundational to this channel, because it really explained a lot of what I knew and understood to be true. A lot of things that other people were saying that I didn't understand, such as Ed Rivera. His writings are a little bit complex, and the jurisdiction report put out by Eisenhower is pretty easy to understand. And since Eisenhower was in the military, it kind of had that, I think, that military slant to it. So I understood it quite easily. And then all these things that I had learned being in the military and working for the military that I began to understand more clearly. And so that's how this channel came about. So in Roe versus Wade, which is about the abortion issue, I don't really want to get into whether abortion is right or wrong. People can make their own decisions. What I want to talk about is something that was mentioned in a recent video by Judge Andrew Napolitano, where he stated that judges have to interpret the law. Previously, the same judge stated that judges must follow the law. Okay, so they have to follow the law, but yet they interpret the law. I guess both are true. A lot also of what I've learned has come from Napolitano, such as the positive law and my research on that, which I have shared with everyone. So I've gone over some of these papers in previous video. So if you watch this video and you want some more information, you can go back and look for a previous video. And I think those videos are on the statutes with multiple personality disorders and the vagueness of law, and then the fact that judges have to then interpret the law since the laws are vague and the problems that lead to. So I'm going to show you 3 different things that I have here, which you can look up and read for yourself so that you can better understand the vagueness of law. Now, these are written by attorneys. One of them is a congressional record. And so you have to stop and you have to do your own thinking while you read these papers. Being law papers, they may have a slant to them. And being that the Constitution does not define the independent state and the dependent state, there also may be some cute confusion on that. So once you understand the dependent state and the independent state, you can properly categorize where these laws apply and where they don't. Okay, so this is what I want to talk about. The thing we want to pay most attention to in this video are the 2 key words, intent and interpretation. Okay, so you know what both of those things mean, and that there's a difference between the two, and that when they talk of intent, they're talking of what the law specifically means. What is the intent of the law? What is the purpose of the law? And when there isn't a clear intent, which usually there isn't, then judges and departments and agencies are left to interpret the law, okay? So we have a federal Congress which writes laws. Each law should have an intention of what it's for, okay? And who it applies to and all that, but that's included in the intention. When the intent is not clearly stated, the departments, officers, agents, etc., interpret the law so that they may, apply it in a way that suits that department. The problem is when the federal Congress writes laws that are so vague that the intent is difficult or impossible to find. Then the so-called law becomes so difficult to follow but easy to interpret in a way imagined by any agent, employee, department, judge, justice, court, etc. So without a clear intent of a written law, the imagination of a person can run wild as to what the intent was or is. And therefore, it being the law is interpreted in the way imagined by the person doing the interpreting. So Congress makes laws and they write them to be very vague. And so when the laws are passed and signed, the departments and the agencies are just left to figure out how to apply the law and who to apply it to. Then, if there's a problem, the judge has to figure out if the interpretation by the department or agency or employee was correct or not. Okay, so this leads to a lot of unnecessary problems. For an example, let's say that in my home, I make the rules. I have a rule that no one work, quote, work, end quote, on Sunday. So I go into my child's bedroom and he's painting a picture and I scold him for, quote, working. But he claims it is not, quote, work because it is, quote, fun. But I disagree since he sells his paintings for a profit. Therefore, the rule I made was vague and it was applied in the way the child saw fit for his own benefit. He used his imagination by stating that it was not, quote, work, it was, quote, fun, and therefore he didn't break the law. In Legal Fictions by Lon Fuller, he uses much the same type of example. So he says, Congress makes a law, and the law states, no, quote, sleeping in train stations. A homeless person brings in his bedding, sits upon it, and appears to have every intention of sleeping, but hasn't yet closed his eyes. A paying customer, on the other hand, has a 5-hour layover between train rides, sits upon a chair and closes his eyes, and he's quickly arrested for, quote, sleeping in the train station. Therefore, we have a vague law of no sleeping, which is undefined. Sleep is undefined. The homeless person is not arrested because he has not closed his eyes. The paying customer is arrested merely because he closed his eyes. Many of the laws we have today are vague. Now, in this section, I bring up the maxims of law. Maxims of law are truths that have stood the test of time and which speak out against these types of laws. So, the first one, quote, that which is just and good is the law of laws, end quote. Makes sense. That which is just and good is the law. So when a man is arrested for closing his eyes in a train station, does this sound just and good? When the judges and employees are left to use their imaginations as to what the law means or means to them, does this mean or seem to you to be just and good? 2, fiction yields to truth. Okay, so in this maxim, we see that it's ancient law and it's been accepted through time that fiction or imagination or what a law might be saying or wrong interpretation must yield to the truth. Therefore, intent of the law is the truth when the law is within its boundaries, but a fiction or interpretation or something imagined must yield to what's true. But how do we know what's true when the law itself is vague? 3, quote, to conceal fraud is fraud, end quote. Any court or judge or employee or agent who takes part in concealing fraud is committing fraud. Any judge acting on behalf of his, quote, imagination, end quote, or, quote, interpretation, end quote, would be committing fraud when he imagines or interprets outside his jurisdiction, or that is his scope of power or authority, because jurisdiction means the power or authority to do something. And if you look at the Constitution, power under Article 3 is capitalized, meaning that they only have very specific powers. Doing such has placed this country in a particular and detrimental position, which moving backward to undo what has been wrongfully done may have disastrous consequences due in part to the number of weak-minded individuals we have in society today. And I point to you to the people picketing at Washington at the Supreme Court over the paperwork alluding to a possible overturn of Roe versus Wade. Number 4, quote, "Truth is the mother of justice," end quote. For society to have and obtain true justice, we need truth. The truth of the Constitution and the laws of the United States is clearly and vastly unknown to most of the American people. It's clear that they do not understand the Constitution. 5, quote, "It is infamous to lay snares for the innocent by means of the forms of law," end quote. Can you think of any way in which the Congress has laid snares for people, such as vague laws, such as allowing judges to, quote, "interpret laws," such as not showing the intent of the law, and so on and so forth, contracting with people and telling them that they have to comply, but yet they also have to sign the papers, signatures required, because they can't do anything if you don't sign the papers. Well, if I don't sign the papers, does that make it not a law? So is that a snare for innocent people? 6, quote, "Craft is not justified by any way around it," end quote. This appears to state that vague laws are crafty and that interpretation by way of imagination is also a craft and is crafty or crafting. So they're crafting laws. They're being crafty. They're rubbing their hands together saying, what can we get here? We're going to be crafty. And we're going to craft the laws to snare the innocent. There's no place for law for crafts. This would be fraud. It would be deceptive, lacking truth and honesty, and therefore justice cannot be served, and therefore the innocent is not protected. They're caught in snares, sometimes referred to as hooked bills. 7, quote, "To conceal is fraud," end quote. To lie is to conceal, and to conceal is fraud. Intent of law, concealed through legal ease, is fraud. We see that even correcting a wrong by the Supreme Court is a difficult process which caused an uprising in protesters. The protesters, however, in my opinion, should return to their state and picket their state legislators. And if the state legislators decide that the issue of abortion is beyond the business of the state, then they should make laws for or against it. Therefore, the state, in that case, should remain neutral. They should not make laws for or against it if the legislators decide that abortion is beyond the business of the state. And so the abortion issue is neutral. No laws for, no law against. So here in this article that I have up, which is called Statutes with Multiple Personality Disorders, the value of ambiguity in statutory design and interpretation, from the Michigan Law School. The article explains why statutes are vague, why Congress allows for the vagueness of statutes, and due to this vagueness, departments interpret the statutes, and judges interpret the statutes in agreement with the interpretation of the department. Ambiguity or vagueness serves a purpose for the legislators, allowing them to obscure meanings, which allows judges to interpret statutes. However, many judges have come about a variety of interpretations, which sometimes contradict each other. And so we have a problem of exploitation by the so-called government. This allows for the creation of problems rather than solving them or allowing for justice to be served, instead just creating opinions through imagination. This is also problematic since the Constitution appears to be mostly misunderstood as a government over the independent states instead of a government of the federal areas, also called states. The Constitution can be construed or interpreted in any number of ways since it is ambiguous. Each Supreme Court justice may have a different view of what the state is, and the laws thus written in connection with the Constitution, also being vague, allows for so many difficult problems that nothing is ever actually resolved or solved. We simply have problems, compounded problems, due to various and many imagined interpretations of the Constitution and the laws of the United States. We have a Supreme Court taking and hearing and deciding by interpretations the issues that are in fact left to the states, the independent states. There's nothing in the federal Constitution allowing the federal government to make many of the decisions it has been making. This leads us to state rights, the independence of the states, the fact that the states created the federal government, and the federal government is supposed to make rules and regulations or laws for the federal areas to which jurisdiction, that's power and authority, was ceded to the federal government for the purposes specifically lined out in the Constitution. This is why, in fact, the federal government not only had to ask for the lands from the independent states, but also for the right to make the laws called jurisdiction or accession of jurisdiction on the federal lands or for the federal lands, as well as the federal citizens on those particular federal lands. So you have an independent state which ceded lands and authority to make the laws for the federal lands. Collectively inside the independent state are called dependent state. Next, we have an essay called Reclaiming the Legal Fiction of Congressional Delegation by Lisa Schultz Bressman. In this article, Ms. Bressman states that judicial review of statutes rests on interpretation, which interpretation is a legal fiction. Here, I remind you of the book Legal Fictions by Lon Fuller. The language in statutes are meant to be, quote, interpreted, that the language is vague intentionally, that interpretation as fiction is used to decide cases, and it was in the Chevron case versus Natural Resources or Natural Resource Defense Council, both, quote, false and fraudulent, end quote. The writer continues to say, by my own understanding, that when statutes are vague, the judges and justices can interpret the law to mean anything they like. That the law is whatever the justice imagines it to be. Therefore, lost my place here. Therefore, the judge or justice can decide however he or she likes, depending on what outcome is desired by the judge, and not necessarily based on the, quote, intent of the law, since the intent is unknown. I would also continue myself to claim that vague laws ensures there will always be arguments and conflict. That ensures there will always be a need for judges to hear cases, and that someone will always be paying something, since there will always be someone who loses. This creates a situation where someone, likely the one who is more favored, will win something, receive a payment that the federal courts always have a case to hear, which cases to be heard requires a payment and the hiring of attorneys. The entire system of ambiguity only allows the controllers to continue to control, in my opinion. The writer, Ms. Bressman, also states, quote, Congress has directly spoken to the precise question at issue. If the statute is clear, then the meaning controls. But if the statute is ambiguous, the second step instructs courts to defer to the agency's interpretation as long as that interpretation is reasonable. Well, who decides what's reasonable? It's the courts. So the court decides what they think they can decide. So the courts are deciding what's reasonable based on their idea of what's reasonable. So of course, they're always going to decide that interpretation is reasonable and then make a decision. And what is unreasonable? If the statutes weren't vague, there would not be a requirement for interpretation. Interpretation is entirely beyond the jurisdiction of the department, but the department sees that it can make more money by expanding its jurisdiction. And if an issue is brought to court, the judges will side with the department and its expansion of jurisdiction, which is precisely what has occurred, as not once is the word, quote, state, end quote, as used in the Constitution, defined clearly and located in a place easily found, such as in the records, by those who search for it. And there's no difference stated clearly between the independent state and the dependent state. And therefore, we have a Supreme Court and a federal government given power over the states it created for military purposes, and yet it has been deciding cases for the independent states and trying to regulate the people of those states when it has no actual power to do so. It only has ambiguous statutes, an ambiguous constitution, and interpretations in its own favor. Here we could get into the issue of the independent states and the dependent states. It may be better to keep this topic for a different video, but unfortunately, all these things are connected. From here, we take a look at the Congressional record. This record is from 1867. It's from the Congressional Globe. It's page 1565. 1565. It's Mr. Cowan speaking. And he asks a question, which is plain and simple, and he asks President Lincoln for a like reply, a plain and simple one. Quote, right here. Why, Mr. President, what is a legal state government? Is it a government cooked up for a state here in Congress, or is it a government that the people of the state make for themselves? I like a plain answer to a plain question. Who made these state governments? This is the simplest way to explain the, quote, situation, end quote, of the governments. So, the people, being those living in the state, the settlers, inhabitants, natives, etc., they make a state. They form a state government for themselves, such as Republic of Texas. They are a free, sovereign, and independent state. When a state is independent, it is said to be sovereign. When it has sovereignty, it is free. Those independent states allowed some lands to be sold to the federal government, and the federal government who purchased those lands collectively within the independent state, those lands that they purchased became a dependent state. So, such as the early congressional laws or congressional record shows, Virginia, quote, Virginia ceded lands to the United States for the erection of the legal state made by Congress called State of Virginia. That's not a direct quote. Virginia ceded lands to the United States for the erection of the state of Virginia. So Virginia, the lands of the people, ceded some small parts of its state to the United States for the erection of a legal state created by the men in Congress. So the independent state Virginia and its people, the settlers, inhabitants, natives, gave some land, sold some lands to the United States for the erection of a dependent state, and that dependent state is the federal state called State of Virginia, which is a legal state created by the men in Congress. So this means Virginia sold lands to the United States. With the sale of the lands, Virginia gave up the right to make the laws for the lands. Those particular lands, the dependent state, the federal military lands. So the federal government acquired the right to pass laws for the federal lands, the state of Virginia. When both of those things were done, so choosing the land, selling the land, and then ceding lawmaking authority over those lands, when both the things were done, the federal government had then successfully erected their federal state, a dependent state, state of Virginia, inside Virginia. Therefore, there is a dependent state, which is a federal state, inside the independent state, which is the state of the people. Let's read what the congressman said once again. Mr. Cowan speaking, and he says, quote, "Why, Mr. President, what is a legal state government? Is it a government cooked up for a state here in Congress, or is it a government that the people of the state make for themselves? I like a plain answer to a plain question. Who made these state governments?" End quote. I hope this makes more sense now. When the Constitution talks of the Supremacy Clause, it talks of the supreme laws, which are the federal laws, on the federal lands. The entire Constitution is about what the federal government agrees to do on the federal lands. Since once lawmaking power was ceded to the federal government by the legislatures of the independent state, the Constitution became the supreme law on the lands of the states it created, being the Constitution which applies on or to the dependent states, which are the federal lands inside the independent state. So the military areas. The military areas inside the state collectively create a legal state controlled by Congress, because Congress makes the laws for the United States. These dependent states are the, quote, United States. They are dependent states. And the federal government is supposed to be controlled by the independent states, which are civilian states, the states where the civilians live. We are civilians because we are not in the military. And unless you are in the military, and if you are in the military, you're federal property, and you know that. Now, I believe this is why Judge Napolitano called the picketers in Washington, after the Roe v. Wade papers were released, that something like it was absurd or silly, something to that effect. I agree, since the picketers are not understanding the nature of government and what it is and what it is supposed to do, as well as what powers it has and what powers it does not have and what it is not supposed to do. The reason why it's so hard to explain this to people is that there's a lot of backlash. People, even people who just want their freedom so bad that they can taste it in their mouths, will reject the exact information that they need to understand in order to be free. That's why this is so difficult. The federal government and the Supreme Court are to make and administer the laws on the federal lands for purposes of defense. And basically, that's all. There are some treaties and a few other things. So, our two parts to this issue is vague laws, which include interpretation using imagination, and two, the idea that states have no rights over the federal government when in fact the independent states created the federal government, and the federal government oversees its federal areas called dependent states. So the independent states oversee the federal government, and the federal government oversees the military areas, which are the dependent states. Many issues in the Supreme Court have been decided are actually issues that should be left to the independent states. Supreme Court only should be deciding cases for those dependent states, which are the federal areas within the independent states, and the people on those federal lands, mostly military, some civilians who are working with the military. those people who receive their income directly from the government, the federal government. It will be interesting to see how this backtracking by the federal government will work out in the future. Again, I would like to state for anyone who listens to my videos that I do not encourage people to picket, protest, march, disrupt, invade, antagonize, harass, or any other thing to or against the federal government. These acts may be interpreted wrongfully as acts of aggression, even when peaceful, but also may entice those with a particular negative agenda to act out when the intent was to be peaceful, causing those involved in peaceful protests to appear as aggressive perpetrators. I believe that we can do more, do better, and do well, and promote freedom, sovereignty, liberty, and independence through education, knowledge, and wisdom. I believe that knowledge is not only power, but that a lack of it binds us. So be kind, work hard, and learn a lot.